I'm Rick Hasen. I'm a professor at UC Irvine School of Law, where I specialize in election law. Well, I started in the graduate program in political science at UCLA in the mid-1980s, and I was studying Middle Eastern politics. So I was doing that for a few years. And at some point, I realized that my advisor and I had very different ideas about how I should proceed in my studies. And so I said, well, I need to make a change. And I'd been enjoying studying political economy and law and economics. And I said, well, maybe I'll try law school. And so I started law school at UCLA, staying in the PhD program, figured I'd drop out of one of those. Ended up finishing both and writing my dissertation on topics about law and social science, law and economics, law and psychology. There were chapters on tort law and contract law and election law. I took election law as a student of Dan Lowenstein's at UCLA, who's one of the few people at that time teaching the course. Then fast forward a few years to my first teaching job at Chicago Kent, where they said, what do you want to teach? And I said, oh, I think I should teach election law. It's the melding of law and political science. I went ahead and did that. I reviewed Dan's book for the Journal of Legal Education. Dan thought I had some pretty good ideas about how the book could be improved and asked me to come on as a co-author. So I did. And election law became something I specialized in more and more, even though that wasn't where I was when I started. I remember I interviewed for a job at the University of Texas and interviewed with Sam Issacharoff, who's one of the leading election law people now at NYU. And Sam said, well, you're an election law person. And I said, no, I'm not. And he just told me I didn't know it yet, that I was. And in fact, I was. And by the time we got to the 2000 disputed presidential election, I was well established in the field. And then the field really exploded after the 2000 election. And now the course is taught at most or many of the top law schools in the country. Rather than there being just the two election law books, what was the Lowenstein book now is Lowenstein, Hasen, Takaji, and the Pildes Sakharov-Karlin book. Now there are 5 case books, and there's an election law journal, which Dan Lowenstein and I had started and co-edited for about 9 years, and the election law blog has a lot of readers. The election law listserv has over 1,000 subscribers, and so it's really become an established field since I started teaching in the mid-90s. Well, social science comes into play in all kinds of legal disputes. You think about, for example, when the Supreme Court considers a death penalty case, there's social science evidence about statistics and whether the law is racially discriminatory, or you think about environmental law where science and social science can be relevant. So all kinds of places social science can be relevant to how courts, and especially the Supreme Court, might decide disputes. But I do think that political science is especially relevant to election law disputes. So for example, when the court decides about the rights of political parties to hold primaries that are open or closed, and how that might affect whether you get more moderate candidates, which is one of the theories about more open primaries, is that you'd end up with more moderate candidates. The court has to understand the social science. In the campaign finance area, when the court talks about whether campaign limits might prevent the appearance of corruption, well, that's something about public confidence. When the court is deciding voting rights cases, that's maybe where social science is the most direct, because in deciding whether or not there's vote dilution, you're going to need social science evidence about the extent to which whites and African Americans, say, vote for different or prefer different types of candidates. And so I think both empirical political science as well as political science theory is uniquely relevant to how the Supreme Court and lower courts decide these kinds of cases. Well, I've always been a political junkie. So while other people, when they were kids, would turn to the sports page in the newspaper, this is a time when people actually still read newspapers. I remember turning to the politics section back in, let's see, this would be 1976. I remember writing an essay about why I thought Jimmy Carter should be president. So That was a long time ago. I wasn't too old then, so it has been a long-standing interest of mine. At one point, Adam Liptak of the New York Times referred to me as America's #1 election law obsessive, and I think that's probably a pretty accurate term. Anyone who follows my blog knows that I follow the developments in the field very closely. Well, I don't know that election law is more contested than, say, again, death penalty jurisprudence or environmental disputes or even intellectual property disputes. That is, people who care about these issues care about them deeply, and there are fundamental disagreements about first principles and about application of principles to particular legal disputes. What I think is different about election law is that partisan conflict is not only enduring, Democrats versus Republicans, even as the Democratic and Republican Party have changed very much in their overall ideological orientations from, say, the 1960s to today. Partisan conflict has always been there. But it's also true that over the last couple of decades, the American public and political elites have become much more polarized, much less bipartisanship, much more of a winner-take-all understanding of politics. And I think that has made some of these battles quite fierce. And so issues where there used to be bipartisan consensus, for example, there used to be a fair number of Republicans who supported campaign finance reform, and a fair number of Democrats who opposed it. It's now become yet another partisan issue, which I think is unfortunate. But I think if you look across the breadth and width of election law disputes, you will find many of them are animated by partisan politics. Many of the arguments that are made are situational. So when the candidate, whether Democrat or Republican, is behind in a very close election that goes to election contest, the mantra is count every vote, which we might today associate more with the Democratic side than the Republican side in terms of trying to count more votes and franchise more people. But really, when it's a close election, it's situational. And so when Norm Coleman is behind Al Franken in the disputed Minnesota U.S. Senate race, it's Coleman that's calling for counting more votes, and it's Franken that's calling for finality. So naked politics sometimes overshadows the ideological disagreements between the parties. There are many disputes within the political science field over what's causing polarization, whether it is something that is driven mostly by elites or trickles down to the public, whether it's enduring, whether it's not. I do believe that one of the reasons that we have more polarization today is thanks to the passage of the Voting Rights Act, as well as the Civil Rights Act, and other laws which tended to cause the realignment of the political parties. So if we go back to the South, before the Civil Rights Act and the Voting Rights Act, there were a fair number of conservatives who were in the Democratic Party. And at this time, think of New England, there were many liberal Republicans. Think of Nelson Rockefeller. Think of, even think about the Maine senators, Olympia Snow, for example. When you think about what's happened today is that the Voting Rights Act and other laws have caused this realignment where even the most conservative Democrat today in Congress is more liberal than the most liberal Republicans. We have a kind of a clean ideological division between the parties. We have this division between the parties, those to the left in the Democratic Party, those to the right in the Republican Party. They're pretty well sorted. And on top of that, we have this divided government. And when you have a situation like we have now, where you have the president of one party and the majorities of Congress of another party, you not only have ideological division, you have that on top of separation of powers, which leads to gridlock, which makes it difficult to get things passed, which causes additional partisan recriminations. And so I think that those kinds of tensions just exacerbate what we already see between the parties. Well, if you go back to the 1950s, we see that the parties were much less ideologically divided. If you look at how members of Congress voted, they didn't divide so neatly along party lines like they do now. So I do think something is different now. And while it is true that the constitutional system of the Founding Fathers was designed to make it difficult to pass legislation, perhaps not this difficult. And so I don't know. Remember, back at the time of the Constitution, Founding Fathers were skeptical of political parties. I don't think they envisioned the party system, certainly not the party system that we have today. Let's contrast this with a place like the United Kingdom, where there's certainly partisan division between those on the left and those on the right. But because there's unified government, the government can actually get something done. So you can have the Labour Party in, you can have the Tories in power. They can actually enact their program. Voters can like it and re-elect, or they can dislike it and throw the bums out. But because we have this diffusion of power which lays below the partisan conflict, it makes it just much harder for voters to figure out who to blame or who to reward. And I think that contributes not only to additional polarization, but to the sense that nothing can get done. I don't think that people complain in England that nothing's getting done. People might not like the substantive policies, but at least you say, all right, well, that's what the government chose to do. Do we like it or not? Well, does money matter for polarization is another question that divides political science. There's an interesting new book. It's out by Ray LaRage and Brian Schaffner, which argues that campaign finance reform actually has exacerbated polarization. And the theory is that those who give money are those who are most intense in their political beliefs. They tend to be more extreme on the left or the right. They fuel the kind of ideological politics that we see today. And they argue that if we want more moderation, we need to go through the political parties, which are more of a big tent. That political parties could serve, if they could be brokers, could serve to create more moderating politics. These arguments are disputed. There's plenty of polarization, even in places where parties are strong. And so it's not clear that this would, that changing our campaign finance system would make things less polarized, more polarized. In my book, I actually argue that if we gave every voter money to allocate through campaign finance vouchers to political parties, to particular candidates, even to interest groups, that we would actually have that would have a moderating effect on our politics, because if everybody had $100 to give, many moderate voters would choose to give to groups that reflect their views. And so if money were distributed in this way and not just to those who felt the most passionate about politics, it actually could cause our parties to become, or it would actually cause our politics to become less extreme. I also suggest that if we really think political parties are so essential to the moderation of our politics, we might choose to have some of these vouchers given to political parties from the voter. So a voter could say, of the $100, the voter would have to give $10 to a political party, or not give it at all, but would have to be allocated to a political party or to no